Tatu, a prominent businessman of Arunachal Pradesh, is under the controversy. The accusation that his ST certificate indicating affiliation to Nishi tribe is received through a fraudulent means, and his indigenous identity false, a fabrication designed to reap the benefits associated with ST status. This controversy has ignited a larger debate about identity, belonging, and the process of claiming indigenous heritage in Arunachal Pradesh. The controversy surrounding Tatu is not an isolated case. Many others are being questioned for the same. This ST status controversy shines a light on the complexities of identity politics, particularly in Arunachal Pradesh, where indigenous communities are striving to protect their cultural rights and social rights from the threats of increasing unemployment among youths, influx of outsiders, government schemes and economic opportunities being used by non-indigenous increasingly. The case highlights the challenges of verifying claims to tribal affiliation and the potential for misuse of affirmative legal rights and policies. It also underscores the urgent need for fair, transparent, and sensitive mechanism to address such disputes, ensuring that the rights of both individuals and communities are safeguarded. As the controversy continues to unfold, it leaves us grappling with uneasy questions. How do we define belonging? What constitutes proof of tribal identity in an era of intermarriage and migration? And how do we balance the rights of individuals with the collective rights of indigenous communities? These are not merely legal or administrative issues, they are deeply personal and societal questions that demand our careful consideration. Leading the charge against Tatu is Lokam Talo, a prominent figure representing the Arunachal Pradesh Scheduled Tribe Welfare Society. Talo's stance is clear. He does not believe Tatu is a genuine member of the Nishi tribe. Talo's challenge is rooted in his assertion that Tatu has failed to provide sufficient evidence to support his claim to Nishi heritage, and his father to be a non-APST. According to Talo, Tatu's ST certificate is a product of deceit, obtained through fraudulent means. Talo has called upon the authorities to conduct a thorough investigation into Tatu's background, urging them to find the truth. At the heart of Talo's challenge lies a deep-seated concern for the preservation of tribal identity and the rights of indigenous communities in government, jobs, tender works and economic opportunities due to prevalence of poverty among APSTs. Talo's stance, while controversial to some, resonates with those who fear the dilution of tribal identity and the potential exploitation of benefits meant for genuine members of indigenous communities. The controversy has brought to the fore the complexities of proving tribal lineage, unavailability of written documents on tribe or clan history, particularly in a region with a history of migration and intermarriages. This challenge underscores the need for a robust and transparent system of APST verification, one that can withstand scrutiny and ensure that the benefits of reservation policies reach the intended APST beneficiaries. On the other side of this tumultuous battle stands the Welfare Society. The society maintains that Tatu's ST certificate is entirely legitimate, obtained through legal and appropriate channels. They argue that Tatu is like any other member of the Nishi tribe, has the right to possess this certificate, and that questioning its validity is a direct attack on his identity and his rights. The Welfare Society has vehemently refuted Lokam Talo's allegations, dismissing them as baseless and malicious. The society points to a court ruling in Tatu's favor as evidence of his legitimate claim to ST status. However, despite this legal victory, the controversy continues to rage, highlighting the deep-seated mistrust and the high stakes involved in this battle over identity of APSTs and the problems surrounding it. It raises questions about the limits of scrutiny, the burden of proof, and the potential for harassment faced by individuals accused of falsely claiming tribal affiliation. It underscores the need for a system that balances the need for verification with the protection of APST rights and dignity. Let us trace the PRC and ST certificate saga and understand how this is directly related to identity issues. PRC and ST certificate issues have been a long-standing issues of Arunachal Pradesh. The contentious process of granting and issuing of permanent residence certificates, PRC, and ST certificates. Over the years, this process has been plagued by allegations of corruption and manipulation by government officials and political interference, leading to widespread distrust and resentment. The seeds of discontent were sown in 2018 when a joint high-power committee, JHPC, under the chairmanship of a BJP minister Nabam Rebia under Pema Khandu-led government, was formed to assess the demands for PRCs from 6 non-indigenous communities: Diris, Sonowal, Kacharis, Adivasis, Morans, Mishings and Gorkhas, residing in Namsai and Changlang districts for decades. In February 2019, CM Pema Khandu and DCM Chowna Main subsequently made a New Year gift announcement to grant these PRCs in an election rally. This sparked violent protests across the state, as many as 18 organizations, encompassing civil society, students' unions announced 48 hours statewide ban call to protest this announcement. Protesters set ablaze vehicles and targeted offices of all Arunachal Pradesh Students' Union APSU and all Nishi Students' Union ANSU, both of which had supported the JHPC's recommendations. The situation escalated further when protesters attempted to storm into the civil secretariat in Itanagar. The army was called in, and internet services suspended. Protesters attacked and burned the residences of Chowna Main and other officials. This protest resulted in shooting dead of many young protesters fighting for the indigenous rights. As a result, the Pema Khandu government had to withdraw the announcement of granting PRCs to 6 communities. The government assured the public that the PRC matter will not be tabled in the assembly and not pursued in any foreseeable future. This episode highlighted the volatile nature of the PRC issue and the deep-seated anxieties surrounding the potential influx of non-indigenous communities and protection of rights of APSTs. After 2019, the focus shifted to the issuance of ST certificates, with the government introducing new guidelines in August 2022 aimed at streamlining the process and curbing potential irregularities. However, this move was met with further controversy when, in September 2022, the government announced plans to cancel ST certificates of individuals born to tribal mothers and non-tribal fathers. This decision sparked outrage among certain sections of society who viewed it as discriminatory and unjust. The government's efforts to address the issue continued in 2023, with measures implemented to expedite the issuance and renewal of Saint certificates, PRCs, and inner-line permits in Changlang district. However, despite these efforts, the controversy surrounding Tatu's and many others' cases demonstrate the issue remains far from resolved. This timeline of events reveals a complex and often contradictory approach to addressing the concerns surrounding PRCs and ST certificates by the BJP government, highlighting the need for a consistent, transparent, and sensitive approach to this sensitive issue of APST rights. Now the question is, who qualifies as a scheduled tribe in India? What are the legal and constitutional framework? It is not determined by mere self-identification or societal perception. It is in fact a matter of law, clearly defined within the framework of the Indian Constitution. Article 366, Clause 25 of the Constitution provides a definition of scheduled tribes, recognizing them as such tribes or tribal communities or parts of or groups within such tribes or tribal communities as are deemed under Article 342 to be scheduled tribes. Article 342 further elaborates on this definition, outlining the process for amending the list of scheduled tribes. It states that the President of India, after consulting with the governor of a state, can specify the tribes or tribal communities deemed to be STs within that state. This list, however, is not static. Parliament, through law, can modify this list, adding or removing communities based on specific criteria and socio-economic indicators. This constitutional framework is further strengthened by a series of laws and regulations designed to protect the rights and interests of scheduled tribes. The Scheduled Castes and Scheduled Tribes Orders, Amendment Acts for instance, play a crucial role in specifying the communities recognized as STs. Additionally, the Forest Rights Act of 2006 recognizes the rights of forest-dwelling tribal communities over their traditional lands and resources. The 5th and 6th schedules of the Constitution also contain specific provisions related to the administration of tribal areas and the protection of tribal cultures and customs. These legal and constitutional safeguards underscore the Indian government's commitment to recognizing the unique challenges faced by scheduled tribes and ensuring their social, economic, and political empowerment. In Arunachal Pradesh, a dangerous game is being played out. The controversy PRC and ST status has exposed the game of increasing politicization of identity. This sensitive issue, with its potential to divide communities and incite unrest, has become a tool for political maneuvering, often at the expense of truth and justice. Politicians in power are eager to consolidate their vote banks, have been accused of exploiting and making promises during election rallies without concerning the APST and indigenous rights for their own gain. The issue of who gets to be recognized as a scheduled tribe, with its associated benefits and protection, has become a battleground for political parties seeking to woo voters. This has led to a dangerous game of vote bank politics, with accusations of appeasement and discrimination flying thick and fast. This has created a climate of fear and suspicion, making it increasingly difficult to have a nuanced and reasoned debate on this complex issue. The consequences of this politicization are far-reaching and potentially devastating. It not only undermines the legitimacy of the process of determining saint status, but also erodes trust in the institutions responsible for upholding the rights of indigenous communities. Furthermore, it creates division within society, pitting communities against each other and jeopardizing the delicate social fabric of Arunachal Pradesh. Instead of resorting to divisive politics, political leaders must prioritize the well-being of all communities and work towards finding solutions that address the concerns of both indigenous and non-indigenous groups in Arunachal Pradesh. The issue, like Tatu's, must be settled with voluntary participation of concerned parties in finding an amicable solution through legal ways, including court-ordered legal DNA tests, to wrest the controversy once for all.